Jayadev Galla.
Thank you, Madam, for permitting me to speak on this bill that has passed through the joint committee of which I was also a part of. It is connected to the Insolvency and Bankruptcy Code since both the bills are intertwined, as the first bill aims to address the issues relating to insolvency and bankruptcy of individual and companies. And this bill's objective is to fast-track in disposal of debt recovery applications pending before tribunals. It also proposes to arm the RBI with powers to regulate asset reconstruction companies and helps to work in tandem with the government initiatives to reduce the NPAs of banks by providing a framework that would quickly bring willful defaulters to book and enable creditors to recover their dues. When I talk about NPAs, I should mention about the rapidly rising NPAs of banks, as many of my colleagues have already done. The gross NPAs have gone from 2.67 lakh crores, which is at 5.45% at the end of financial year, to 3.6 lakh crores, which is 7.3% as of December 2015. This is a very serious situation, and I'm sure and confident this bill will help in reducing these NPAs and 70,000 cases that are pending involving more than 5 lakh crores of rupees in debt recovery tribunals in India today. So I welcome this bill and congratulate the Honourable Finance Minister for bringing this legislation. Madam, the bill is proposing to amend 4 acts: the SARFAESI Act of 2002, the Recovery and Debts Due to Banks and Financial Institutions Act 1993, the Indian Stamp Act 1899, and the Depositories Act 1996. Out of these, 4 of the major amendments are proposed to the first 2 acts. So I focus more on the first 2 acts. First, I'll talk about the SARFAESI Act, Madam. The committee has brought out some valuable modifications with regard to the definition asset reconstruction company and brought it in tune with the Companies Act. But if one looks at the provisions of the SARFAESI Act, it did not specifically mention cooperative banks, Madam. The Government of India in 2003 brought cooperative banks under SARFAESI Act through an executive order. But if you look at the present amendment, it does not include cooperative banks. This issue is sub judice since banks are registered under the state acts. Here, the objective is not under which legislation they are included, but the objective is to bring down NPAs of each and every bank, Madam. Even RBI was in favor of bringing state, district, and urban cooperative banks under the SARFAESI Act. So my point is, solution to a problem is more important than legislative competence. The Honourable Finance Minister himself is a legal luminary, so I'm sure he can find some way to include cooperative banks under this Act as well. The bill also does not have a definition for borrower. It should specifically include a person who has taken loan or advance from an institution other than the bank. Say, for example, if a person takes loan from an NBFC and subsequently such loan has been acquired by the bank. In such a case, when banks try to recover dues under the SARFAESI Act, people are going to court by simply arguing that the original lender, the NBFC in this case, is not a secured lender under the SARFAESI Act, and the acquired bank has no jurisdiction. So I suggest for consideration of the Honourable Minister to also include definition for borrower to make this more clear, sir. This bill also helps in ease of doing business. For example, reforms proposed in the registration system will improve access to credit because lenders will be able to ascertain whether there are any encumbrances on property offered as security and speed up loan applications. And with easy accessibility to credit, more entrepreneurs will be encouraged to start new business ventures, which will ultimately improve the ease of doing business. Amendments to the SARFAESI Act are also important because if you look at the implementation of this Act, it is quite pathetic, Madam. It is because of the hurdles that the DRTs put in place. I will give an example. When action for recovery of non-performing loans by banks or financial institutions under Section 13(4) of the SARFAESI Act, the borrower immediately files an application under Section 17 before the DRT. And the DRTs are routinely granting ex parte stay of such action, and thereafter the matters will hang in fire for years together. So I suggest for consideration of the Honourable Minister that the stay under Section 13(2), 13(4), and 14 of the SARFAESI Act up to 10 lakhs should be given to district magistrate or civil court instead of giving elbow room to borrower to maneuver and sneak away under Section 17 from DRT. A positive aspect of this bill is that it proposes to integrate registration records of other registration systems operated by states and other central laws, such as the Registration Act, Companies Act, Motor Vehicle Act, and with the central registry for recording rights over any property or creation, modification, or satisfaction of any security interest on such property under Section 20A. Secondly, it also enables extension of registration system to all secured and unsecured creditors and taxation authorities issuing attachment orders with the object of creating a central database of encumbrances and property rights under Chapter 4A. It is also a welcome measure. I have a small suggestion to make with regard to Clause 10 of the bill, which proposes to amend Section 12, which deals with penalties for non-compliance of directions of the RBI. 1 crore is proposed, Madam. It is good enough, but no time frame has been fixed within which it has to be paid. Since the amount is quite a bit, I submit that the penalty should be paid within a period of 30 days from the date of issue of notice under 12C2. I now come to amendments regarding the Second Act, or in other words, the RDDB and FI Act 1993. Clause 26 of the bill proposes to amend Section 6 of the Act. The proposed amendment increases the age of the presiding officer of a tribunal from 62 to 65. But there is a proviso which says, provided that any presiding officer of a tribunal who has completed his term shall also be eligible for a reappointment as a presiding officer. It means the PO can be appointed again and again, Madam. How many terms can he be appointed? The amendment is silent. I suggest for the consideration of the Honourable Minister that only one additional term may be permitted, because by that time he will already be 70, and that would be the right time to leave such a crucial office. The second point I wish to make is relating to Clause 29 of the bill, which proposes the substitute subsection 5 with a new subsection. But in this clause, no period has been specified within which defendant has to submit the documents. So I suggest that it should be specified that the defendant will not have any right to file written statement after expiry of 45 days. Otherwise, the defendant may take undue advantage by not filing written statement by taking excuse of non-availability of original documents, which will prolong the litigation and defeat the very objective of the bill. I will now talk about the vacancies in DRTs and DRATs. Out of 5 chairpersons of DRATs in the country, only 2 are in position today, and 3 are lying vacant. Out of 39 presiding officers of DRTs, 30 are in place and 9 are vacant. There are 3 DRTs, 2 in Hyderabad and 1 in Visakhapatnam. All these 3 posts of presiding officers are lying vacant, Madam, in the states of Andhra and Telangana. I want to know from the Honourable Minister what steps he is taking to fill the vacancies and by when they are likely to be filled. Also, I welcome that Clause 30 of the bill permits electronic filing of recovery applications, documents and written statements. This is not a good move, Madam. I'm sorry, this is a good move, Madam. Sorry. It should be followed in all judicial matters. This will not only save time but also money. With these observations, I once again support the bill and request the Honourable Finance Minister to ponder over the suggestions made by me, which I am confident help in better implementation of the bill. Thank you.